marks a historic and unprecedented day in Ghana's judicial history. For the first time since the nation's return to constitutional democracy in 1992, a sitting Chief Justice has been removed from office. Justice Gertrude Araba Esaaba Sackey Torkornoo's remarkable legal career has come to an abrupt end following months of constitutional crisis that has shaken the very foundations of Ghana's highest court. Born on September 11, 1962, Gertrude Torkornoo's journey to becoming Ghana's Chief Justice was one of steady legal excellence and groundbreaking achievements. Her rise through the judicial ranks represented progress for women in Ghana's legal profession, culminating in her appointment to the Supreme Court in November 2019. After receiving parliamentary approval in December that year, she was sworn in on December 17, 2019, marking the beginning of what many hoped would be a distinguished tenure on the nation's highest court. Torkornoo's legal career had been built on a foundation of rigorous scholarship and dedicated service to the judiciary. She represented a new generation of Ghanaian jurists, bringing modern legal perspective to a court steeped in tradition. Her appointment was seen as a significant step forward for gender representation in Ghana's senior judiciary. However, what began as a promising judicial career would eventually become marred in controversy that would test the very limits of Ghana's constitutional framework. The crisis began in March 2025 when President John Dramani Mahama received not one, but 3 separate petitions calling for the removal of Chief Justice Torkornoo under Article 146 of Ghana's 1992 Constitution. These petitions would set in motion a constitutional process that had never been fully tested in Ghana's democratic history. The allegations were serious and multifaceted. The first petition centered on claims of judicial misconduct and incompetence in the performance of her duties. The second petition, presented by one Daniel Ofori on March 17, 2025, contained perhaps the most damaging allegations: financial misappropriation totaling approximately 261,890 Ghana cedis and $30,000 related to foreign travel expenses incurred in 2023. A third petition added further weight to the calls for her removal, creating an unprecedented situation where multiple complaints were simultaneously changing the fitness of the nation's most senior judge. The gravity of these allegations cannot be understated. They struck at the heart of public trust in Ghana's judiciary, raising questions about financial accountability and ethical conduct at the highest levels of the legal systems. President Mahama faced a constitutional crossroads. Article 146 of Ghana's 1992 Constitution provides specific mechanisms for the removal of the Superior Court judges, but it had never been fully invoked against a Chief Justice. The President, in consultation with the Council of State, was required to determine whether a prima facie case existed against Justice Torkornoo. On April 22, 2025, President Mahama made the historic decision to suspend Chief Justice Torkornoo from office, the first such suspension of a Chief Justice under the Fourth Republic. This unprecedented action sent shockwaves through Ghana's legal community and sparked intense political debate about the independence of the judiciary. The suspension triggered the establishment of an Article 146 Committee of Inquiry, a 5-member panel chaired by Supreme Court Justice Gabriel Scott Poimang. This committee would be tasked with conducting a thorough investigation into the 3 petitions a process that would consume the next 4 months and produce one of the most comprehensive judicial inquiries in Ghana's history. The committee's investigation was exhaustive in scope and meticulous in detail. Over the course of several months, the panel reviewed a staggering 10,000 pages of evidence, heard testimonies from 25 witnesses, and engaged 8 different lawyers in the proceedings. The complexity and scale of the investigation reflected the seriousness with which the allegations were being treated. Justice Pomang and his committee worked with unprecedented transparency, allowing the process to unfold under public scrutiny while maintaining the dignity and due process rights of all parties involved. The investigation covered financial records, travel documentations, judicial decisions, and administrative procedures, leaving no stone unturned in their quest for truth. Throughout this period, Chief Justice Torkornoo maintained her innocence and challenged the process through various legal channels. In July 2025, she took the extraordinary step of challenging her suspension before the West African Regional Court System, alleging violation of her human rights and arguing that she had been removed from her official capacity without a final determination. On Monday, September 1st, 2025, the committee delivered 8 findings to President Mahama at the Jubilee House in Accra. The report, spanning over 1,000 pages, represented months of careful deliberations and analysis. Justice Pomang, speaking at the handover ceremony, emphasized the thoroughness of their investigation and their commitment to ignoring what he termed false claims whilst focusing on substantiated evidence. The committee's recommendations were clear and unambiguous. Within hours of receiving the report, President Mahama acted on the committee's findings. In accordance with Article 146 of the 1992 Constitution, he formally removed Chief Justice Gertrude Araba Esaaba Sackey Torkornoo from office with immediate effect. The presidential statement announcing the removal was brief but decisive, marking the end of a constitutional crisis that had gripped Ghana for nearly 6 months. The decision represented not just the fall of a Chief Justice, but the test of Ghana's constitutional mechanisms and the rule of law. The removal of Chief Justice Torkornoo sent reverberations far beyond the walls of Ghana's Supreme Court. It demonstrated both the strength and fragility of democratic institutions, showing that no office, however high, is above accountability, while also raising questions about judicial independence and political interference in the courts. For Ghana's legal profession, this case represents a watershed moment. It establishes precedents for how future allegations against senior judges will be handled, while also highlighting the importance of financial transparency and the ethical conduct in judicial administration. The vacancy at the helm of Ghana's judiciary now presents President Mahama with the crucial task of appointing a successor who can restore the confidence in the Supreme Court and navigate the complex legal and political challenges facing the nation. As Ghana moves forward from this constitutional crisis, the case of Chief Justice Torkornoo will undoubtedly be studied for years to come as a defining moment in the Fourth Republic's commitment to accountability, due process, and the rule of law.